All right, good morning, everyone. It is November 9th, 2023, and this is the Law and Policy meeting of the California Fair Political Practices Commission. Ms. Contreras, would you please take the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. We'll begin with item 1, public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll move to item 2, approval of the September 2023 committee minutes. Commissioner Baker, any edits or comments on the minutes?
No edits or comments. I move to approve.
I will second. Any public comment on item 2? Hearing and seeing none. Ms. Contreras.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Right, moving right along. Item 3, this is our potential regulatory calendar for 2024. We have General Counsel Mr. Bainbridge to present that. Mr. Bainbridge.
Good morning. The memo we have here is a list of regulation projects that we've collected over the past year to potentially take on next year. I've indicated the source of each of them. Some came from commission interest, some of them came from things that staff had found. This is an initial list. We wanted to get the input of the commission at the commission meeting this month to see which ones they're interested in, all or none, and what other issues the commission might be interested in. It's also an opportunity for the public or anyone else who has additional ideas to get them to us so we can look at them. We actually got an email from San Francisco Ethics yesterday. They had some additional ideas that we haven't really had a chance to look at yet, but we got it late in the day, so we're going to also be looking at those. So it's really just part of the process of developing the reg calendar for next year. Obviously, anything can be changed or added or removed by the commission before we come back. The plan is to come back in January with a proposed regulation calendar, as we've done over the last few years, which just kind of lays out the intended path, which always ends up changing as the year goes on, but find that there's a benefit in telling for our planning purposes and then also for the public that what we're planning on tackling throughout the course of the year so everyone can get their input in early. I don't know if you want to go through each of these proposals. I've just provided summaries and really the genesis for each one, or if there's just questions you want to ask about specific ones, however the commission would like to, or the committee would like to proceed.
Well, I mean, I have questions on just one or two of them, but would you rather have Mr. Bainbridge go through each of them?
I'm open to either. I have questions about one or two, but I have an overarching question that might be a good kickoff. That works out great. Thank you. This has to do, in each one of your summaries, you mentioned at the end kind of what brought this about, put this on your radar screen. And a question I have is there any other outreach proactively with different representative groups? We just had this trip to Fresno where there were some meetings with clerks and officials. We've got certainly the Political Attorneys Association and treasurers. They're obviously day-to-day professionals, but there's CSAC, California League of Cities, and Counties Association. A couple of times we've talked about different groups like the DA's Association, which over the last few years approached us, and the chair and I went and visited with them during one of their annual meetings. And proactive outreach to them was something that we had talked about coming out of that. So can you say more about if historically we've done that type of outreach or if that's something you plan on doing?
I'm not aware historically, since I've been here, of us going out to people and asking if they have regulation ideas. We do have people come to us. I think this is sort of what, this process is sort of what that is this is an opportunity by us having it at Law and Policy and then talking about it once at the commission meeting and then coming back again 2 months later with the reg calendar. I think I see that as the opportunity for people to submit their suggestions and contact us if they have ideas, just as San Francisco Ethics has done.
Yeah, certainly understand. The only one that's hanging out in my mind is because we did visit with the DA's Association and there were many constructive ideas they had for a working relationship going forward. Obviously, that's just one group with one particular area. I just offer that. There's only so much going out and beating the bushes that you do when people have their job to come to you, but that would be one I would suggest as part of our ongoing relationship with them. Thank
you. All right. I had a question on the transfers to interest-bearing accounts regulatory proposal. So under existing regulation, candidate committees can transfer to an interest-bearing account and then transfer back and then spend the money. But under this proposal, we would extend that same treatment to general purpose committees and political party committees. And my question really is just, does the statute provide for that? And why haven't we extended it before now?
I think, yes, it does provide for it, and we have said by advice letter that we think it's permissible. It prohibits, the regulation states that you can't transfer from restricted use to an all-purpose or any other account. And that any other account, which was what caused the question to say, well, then can we use a investment account like you can in every other context, as long as you put the money back before you make any transfers. So what we had said in the advice letter is that isn't any other account for this purpose, because it doesn't have the same idea of you can't move funds that are supposed to be isolated for candidates or for anything other than candidate support and move those into a candidate support account. So that's what the rule was trying to prohibit. They added any other account, which is actually causing confusion. So it's completely consistent with the way everything else is done, and it is consistent with the intent of keeping those funds separate, because you still have to you put it in an investment account, you still have to put it back in the account it came from, and you can't transfer it to an account that's going to have contribution limits. So to answer your question, yes, it's consistent with the law. I think it's completely permissible. We've said by advice letter it's okay. We just think it'd be helpful to clarify in the regulation.
Yeah, and that's really helpful, because I think that last point, we've advised that this is permissible. And so really this regulation is codifying the advice we've given to create greater clarity to improve compliance. So that absolutely answers my question on that one. With respect to the 84308 regulation, I know we've done extensive outreach on that particular issue multiple times. Do you have any specific ideas at this point, or is it kind of a placeholder for as things come in that we'll be revisiting this?
We have specific ideas. Yeah, staff has identified some through providing advice, and Kevin Cornwall, who's been our go-to on all this stuff, has put together a training and training materials, and through doing that, he also identified some potential issues that could be clarified in the regulation. I don't have the specifics for you right now. It's all minor, I guess, is a fair way to categorize it. It's really just clarifying certain sort of holes that we didn't anticipate when we did the regs the first time around.
Okay, all right, appreciate that. And then the last comment I have, and I mentioned this to you like shortly before the meeting, but I think I would propose that we consider adding to this regulatory calendar some follow-up work with respect to cryptocurrency contributions, or cryptocurrency in general. Two separate issues. The first is, as I understand it, for purposes of statements of economic interest, cryptocurrency is not treated as an investment, it's treated as cash. And so that's the advice we've given. That's consistent with our regulatory approach that we adopted recently. And so, but the regulation doesn't state that. That's something that's just in advice. And so I think for purposes of clarity for the regulated community, adding that to the regulation may be something that we want to do. Again, just to ensure that the regulations track the advice we're given. The second has to do with how cryptocurrency campaign contributions are being disclosed and reported. We don't really treat them as in-kinds. We took kind of a hybrid approach with respect to our regulation, which is appropriate. But the way, as I understand it, they're currently being reported, they're being reported as in-kinds, which is a little confusing. And so I think there is probably a better way of advising the regulated community on how you report those contributions, so that it's clear that these are contributions, actual, essentially cash contributions that are coming by way of cryptocurrency. So cryptocurrency, two issues, SEIs, and how the campaign contributions are reported.
If I may, thank you for putting those forward. And on that, this is a little bit of a process question. I don't doubt for a moment that you've identified two things that we may need to do regulations on, and I suppose we'll have interested persons or public comment for that. But would we start with a briefing to find out why they're doing that? Like, what is the gap? Why are they doing it as in-kind instead of, or is that just going to be part of the whole process for pre-notice?
Yeah, we could provide a summary of it. It was when, I lose complete track of time. How long ago was it we did the cryptocurrency regs? 2 years ago? A year and a half? It was originally the way we thought it would be best to envision them, and then we sort of evolved into this idea of using the third parties that can turn them from cryptocurrency into cash. And we probably should have then reevaluated and said, well, it makes more sense to call this a monetary contribution. At this point, that's not a problem because it actually is being turned into US dollars before the committee ever gets the contribution. So the need to treat it as a non-monetary kind of went away with the use of the third-party vendors that were turning it into cash. So I think that's a good fix. We'll look at, do a little research on how it's been going with people reporting cryptocurrency and confirm that this would be a better way of reporting it, obviously before January when we come back with the reg calendar. But I think that makes sense. I have heard that, and kind of after the fact, we went, well, we probably could have done it this way instead. So that makes sense. And what the chair had mentioned on how we've instructed people to report cryptocurrency, we have said it's not a business investment that would need to be reported on a Form 700. So that would be, I think, a good correction. But what we can do, maybe advise at the meeting next week that this is another issue you'd like added to the calendar, and then we can bring it back on the reg calendar, and we'll include a summary of what the change would be and then what the source of the idea is.
Yeah, great. It has been a year and a half. Those are great topics to take a look at. If you're not done, I have.
good.
Great. I had two areas. The first is a potential, if we do a placeholder, and that is if there's going to need to be any adjustments or reexamination of the behest payment changes. So about 2 years ago, again, I'm having timeframe issues, we made some significant transparency changes. I think were very good. And at the time, we said it'll be interesting to come back. I think at a prior commission meeting, we've requested that we come back, a briefing to us. I know that's in the works. And if there is regulatory changes that come out of that, I just want to have that. It's not, I don't even know if it warrants a placeholder yet because we don't know. But I just have that on my screen for the coming year to see if there's anything more we need to do in the behest payment area. So that's one. I'm not as specific as the chair. I don't know what they are yet because I'm very interested in the reflection on how it's gone for the last year and a half or 2 years. So that's the first one. And then the second goes to the carryover contribution. At the last, it says that this was a commissioner request. I saw it at the last meeting and I was not able to finish attending at the Fresno meeting. There was public comment on this regulation that I think has resulted in this being on the agenda. It looks like it's a briefing. It says there's going to be a summary of the rulemaking process. I think our minds would just need to be open if there's potentially anything we decide to do as a commission, not saying there is, to coming out of that, after that very substantive public comment. So I don't want to get ahead of myself. I'm eager to hear the briefing in January, which seems like an appropriate time frame, but I would just know that we may make changes after that. We may not. We'll just have to see. I'd like to have that noted. That's all.
So noted.
Thank you.
On behested payments, I did have a question because recently somebody mentioned something to me. And when a public official files a behested payment with us electronically, my understanding, and this is just what I was told, they don't receive like an e-receipt or something back confirming that we've received it or the system has accepted it. I don't know whether that would require a regulation to provide for that, or if that's an IT project that we can just do internally. Mr. Bainbridge, hypothetically speaking, if it's true they don't receive a receipt today when they file electronically, but we wanted to require that a receipt be provided, do we need to do a reg for that, or could we just work with IT to make that kind of happen?
No, we can work with IT. In fact, we are working with IT on upgrading that behested payment online reporting system. That's in the process currently. My understanding was they do get a confirmation email, but I may be confusing what is going to happen in the future with the updated system with what happens currently.
Okay.
But that's in the works one way or the other.
Yeah, I knew we were upgrading. I just wanted, on that issue of receipts, I wanted to put that out there. So sounds like you're on top of it. All right. Thank you, Mr. Bainbridge. Commissioner Baker, anything further?
Nothing further, thank you.
All right. Any public comment on item 3? This is our proposed regulatory projects for 2024. These will be presented to the commission next week at the November meeting for additional commissioner comments and ideas with a final calendar to be presented at the January meeting. Any public comment? Hearing and seeing none, we will proceed then. Item 4, this is our legislative update. Similarly, this is our, well, I should say, I think this is our final wrap-up of this past session, and then looking forward, what ideas we have in the hopper to propose for legislation next year. With us is our senior FPPC Legislative Counsel, Ms. Nakano. Good morning.
Thank you. Good morning, Mr. Chair and Commissioner Baker. Today I am presenting 7 ideas for potential commission-sponsored legislation. Some of these ideas are ones that the commission has pursued in past years, and others are new ideas from FPPC staff. For today, I won't go into too much detail on background, especially for those ideas that the commission has discussed in previous meetings, but at next week's commission meeting, I'll go into a bit more background for the benefit of our new commissioner. The first idea relates to lobbying audits, which of course have been on the Commission's radar for a number of years. The bill would transfer the lobbying audit duty from the FTB to the FPPC. There would of course be a significant workload impact, and the Commission would need 9 new positions in the audit division. The second idea relates to placement agents. Placement agents are, generally speaking, individuals who sell investments to public retirement systems, so CalPERS and CalSTRS. In 2010, the legislature redefined lobbyist to include placement agents, so these individuals are subject to the same registration and reporting requirements and restrictions as traditional lobbyists. Placement agent activity is by nature very different than traditional lobbying activity. They lobby a very limited number of agencies. Their activity is typically very low or relatively low and for a short period of time in the state. So staff thinks it makes sense to better tailor their reporting requirements, registration, and training requirements to their activity. The third idea relates to local ethics training. State law requires local agency officials to take an ethics training course that includes ethics requirements in the PRA. After this requirement was passed in 2005, the Commission opted to voluntarily create a free online training course in consultation with the Attorney General's office that satisfies those training requirements. The Commission has continued to offer that training as a free service. We think it's a very beneficial service and would like to continue to offer it, but the system is old and in need of an upgrade. We also don't have funding for staff to maintain the system and respond to the hundreds of inquiries each week that we receive from local officials who are taking that training. Additionally, recent legislation expanded the number of local officials that are subject to those training requirements by more than 2,000 officials, and that takes effect in 2025. The legislation would provide a statutory basis to request additional funding and to continue to offer that training. The fourth idea looks to the good work of the Commission's Digital Transparency Task Force. The bill would authorize the commission of a study to examine whether there are different styles of disclaimers on digital campaign ads that would more effectively inform the voters about who is paying for the ads. That would result in data that could help shape recommendations for best practices and potential future legislation. The fifth idea is new. It came from Senior Counsel Kevin Cornwall in the Legal Division. It relates to our conflict of interest provisions, and in particular, what counts as income for those purposes. For background, the PRA exempts from the definition of income salary and other benefit payments received from a state, local, or federal government agency. The exemption does not include salary from a Native American tribal government employer. This results in uneven treatments under the conflict of interest provisions depending on the type of government salary received, even for similar positions. So the proposal would amend the definition of income in the Act to exempt salary and other benefits received from a Native American tribal government employer for employment in a Native American tribal government position, in the same way that salary and other benefits are exempt when paid by a local, state, or federal government. For example, a person employed by a Native American tribal government who is also a city council member would have to count their tribal government salary and benefits as income for purposes of determining whether they might have a conflict related to a decision of the city council. In contrast, another city council member employed by any other local, state, or federal government agency, even if they had a similar position to the person employed by the tribal government, would not count their government salary and benefits as income for those same purposes. We're still in the process of engaging the appropriate stakeholders, and I will keep the commission updated on any feedback we receive. The sixth idea relates to waiver of the late filing fee. Came to us via the commission's Statements of Economic Interest unit. This proposal would add authority for filing officers to waive the late filing fee beyond the time limits in the Act under additional specific circumstances. So I'll give a few examples of circumstances that the SEI unit has identified. The unit has seen situations involving technical errors where there's no significant loss of disclosure. For example, officials are sometimes allowed to submit a single statement that combines both annual and leaving statements or annual and assuming office statements. When they submit the single statement, the official has to check the boxes for both annual and assuming office. If they accidentally only check one box, technically they haven't filed the second statement, and once they find out they have to, it's late and they're subject to that late fee. So this is a technical error resulting in a late statement where there was no significant loss of disclosure. Additionally, the SEI unit has highlighted situations where the filing officer has failed to send the original statement or forgot to date stamp it, or they had the filer's incorrect email address, leading to the filer not receiving notifications about when their statement is due. The unit also requested authority to grant a one-time waiver for first-time filers who may not yet have sufficient understanding of their filing duties. And that would just be one time, never filed an SEI before, and made a mistake. Seventh is a collection of minor changes and cleanup proposals. Most of these ideas were considered and approved by the Commission for 2023, so I won't go over all of them, but I will briefly go over the changes and the new ideas. First is the proposal that would require redaction of committee bank account numbers on statements of organization. This year, the proposal would additionally require redaction of the names of individuals authorized to obtain bank account records. Next, and this is 7D on page 6 of the report, is a proposal that also came from our SEI unit that would address minor deadline inconsistency for assuming office statements of economic interests. In short, under the plain language of the statute, income is not required to be reported on the assuming office statement if it was received on the date of assuming office. By contrast, real property investments are disclosed if they're held as of the date of assuming office. So there's a one-day discrepancy in those deadlines or in those periods covered. So the proposal would reconcile that inconsistency. And last, this is 7E on page 7, are three minor changes to section 84616 relating to the requirement that local agencies must post all of the paper campaign filings that they receive on their website. These ideas came from Suki Brar, Assistant Chief Counsel in the Legal Division, and they all came up in the advice context, which is to say that local agencies contacted the Commission for advice because the section wasn't clear or simply didn't provide guidance in these specific circumstances. So these proposals provide clear direction to local agencies on what their duties are. I also wanted to update the Commission on the committee on the Commission's potential two-year bills. We have confirmation that Assemblymember Valencia's office will continue to carry AB 1170, requiring electronic filing for statements of economic interest next year. And I have a meeting with Assemblymember Wilson's office next week on AB 868 relating to the Data Act, and we'll hopefully have more news to share at next week's Commission meeting. That concludes my presentation. Happy to answer any questions or discuss anything further.
Thank you, Ms. Nakano. I had a question about 7D, what is being called a minor change to create deadline consistency in SEIs. when was the current law that has different dates for different interests, when was that law put into place? Is that part of the original Political Reform Act?
I believe so. I can double check that, but I believe so.
And do we know why, presumably, an intentional choice was made to treat those differently?
I'm not aware of the legislative intent there. I can go back and look at the records and see if that was considered at all, but I'm not aware at the time.
All right. And then, just generally, have we had problems with this? Is this like an enforcement issue where people are getting in trouble because they're misreporting this? Like, why is this other than kind of just the generic, we like deadlines to be the same, like what's the purpose of this legislation?
So there was a circumstance where an individual received a gift on the date that they assumed office, which is considered income under the Act. Given the language of the statute, they waited to report that until their next annual statement, since the assuming office statement doesn't require to report them on the date of assuming office. Our SEI unit flagged that the electronic filing system is set up so those dates are in the system consistent. So it considers income received on the date of assuming office. It lumps that in with the assuming office statement despite the language of the statute. They have talked to our vendor for that filing system, and they're unable to cover different dates for different types of assets under the current filing system. So that's kind of where this came up and why this came to our attention now.
Yeah, well, I just think for the benefit of complete transparency, then it sounds to me like what we're talking about is we didn't set up our filing system to permit compliance with the law as it exists. And so now we want to change the law to match the filing system that wasn't set up in the first instance correctly. And I have some concerns about that. I don't know if my colleagues have concerns about that, but I appreciate you giving us the full picture of how this has come before us. Commissioner Baker.
Thank you for that observation. I would just want to have you have the opportunity to do the full history on how this happened, if it even was intentional and what that rationale is. But I think you're right. If it's, let's change the statute because of something that we did, should we be changing what we did instead of the statute, knowing that everything is a allocation of your time and resources as well as the legislature? That would just be a question I have. I don't know if it's possible to have it before next week's meeting. I mean, I don't think this is on fire as an issue, but, or what is a reasonable time frame given that legislators are, believe it or not, plotting for their bills for next year. And I would look forward to that. Thank you.
Thanks. Any other questions or comments for Ms. Nakano?
Yes, thank you. I do have some. I'd like to go back to item 5, which was the definition of income to promote equity with particular good notation. I'm glad this issue has been raised to us because I don't think we as commissioners would have known. You're perfectly capable of issue spotting. Some issue spotting I'm going to do now is how we would be sure to distinguish between income that is for the job, working for the tribal government, perhaps for a tribal government position, versus income that comes from the tribal government because they own something. For example, there are tribes that own water bottling facilities, and so an elected may work as a manager or maybe the procurement officer for the water bottling facility. And I think from what I'm reading here and what you said, the intent is to not exclude that from reporting, but say they work as a, I'm not sure, some position for the tribal government that is the fulfillment of traditional tribal government duties. So, another example I can have for you is there are tribal governments that own a grocery store, that own gas stations and outlet malls. And I don't know if the paycheck says it's coming from this tribal government, but it's going to be so critical as this draft develops, at least from my point, to see how we are identifying exactly the type of income that the intent is to treat the same way versus income that we would expect would be reported by anybody else, were they not a member of a tribal government or employed by. So that's a comment. You don't really have to do anything with that, but that's issue spotting. The second is that, of course, tribal governments are also often lobbyist employers. And if there is if that role, I mean, directly, maybe they have an association, like a city is often a lobbyist employer, but they also have an association that does advocacy work for them. I would just be really careful that we're including income that could be related to any lobbying activity, if that's what the person does for the tribal government. Those are my items that I was pointing out. And if we're going to do this, just be really able to answer the distinguishing question, well, why this income and not that income? So, thank you on that. Anything you want to add on?
Oh, yes. I just think context here is important because I don't think we're writing on a blank slate. I mean, I think, first of all, I agree with your concerns. Part of the reason I'm comfortable moving this forward is because, as I said, we're not writing on a blank slate. What we're doing here is harmonizing with existing interpretations of 1090, which do exclude from income the types of tribal government position salaries that I think is our intention here. And so I understand staff's proposal to be to track what is permissible under 1090 in order to effectuate the harmonization, which seems to be the purpose of the proposed regulatory change here. So I think if we do that, we're okay, for what it's worth.
Yeah, and excellent point. I'm glad to know that. And when that comes up, I'll probably ask questions like, okay, so given that we're harmonizing, how does this play out with these different scenarios? Because they are also real-life scenarios. And it's good that we will have, we're not starting from scratch.
Yes,
Always good.
always helpful.
Thank you. The next one is just a quick clarification on item 6. You mentioned the bill would potentially have a sort of one-time, if you're a first-time offender, we'll say, but that's just to provide discretion. It's not automatic.
Yes.
Okay. Just wanted to clarify that point, that the discretion would be provided, not something more automatic. And the last point is more of a strategy point, and this is on one of the 2-year bills, AB 868, for Assemblymember Wilson. I saw some, I'll just say, social media traffic that was critical of one of the social media platforms, in this particular instance, Meta, for in this existing election cycle, it's an off cycle for some places, not having their database of ads updated. It may be, this is part of the conversation. So if you haven't already, you may find out what's going on there. And it may become a point of not negotiation, but a point of persuasion to understand why this might be needed and how things were not working apparently there, and why whatever we're proposing to do here would not suffer from the same problem potentially. So that's a strategy point for you. Thank you.
Thank you, Commissioner Baker. So unlike the regulatory proposal, which would come back for adoption in January, this is something that we want the commission to approve this month so that Ms. Nakano can start reaching out to folks and starting to flesh out some of these ideas. So with that, I would move that we accept the proposed legislative agenda that Ms. Nakano has brought before us and recommend approval to the commission.
Second.
Is there any public comment? This is item 4.
Hi, Mr. Chair. This is Tom Hiltek on behalf of the Institute of Governmental Advocates.
Good morning, Mr. Hiltek.
Good morning. So on the lobbying audit proposal, as you know, this was a bill last year. I testified on behalf of IGA at the Senate legislative hearing, and IGA's position on this is unchanged from what it was last year, which is we support the Commission's desire to find a solution to the audit problem that currently exists at the Franchise Tax Board, but we oppose the Commission's desire to single out lobbyists as a unique subclass of potential auditing of audits, ostensibly because it sort of singles them out as something that requires something special, something different, that there's some problem occurring with respect to lobbying audits. The reality is that the Franchise Tax Board has a staffing problem or perhaps a funding problem or both That applies to all of the entities that it audits. And if you compare the need to audit statewide campaigns, of which there were campaigns that spent tens of millions, even hundreds of millions of dollars that have gone unaudited for a period of time, in addition to the fact that the randomly selected audits of committees, including most of the legislature, have gone unaudited for a long period of time, that the fact that the Franchise Tax Board has not conducted many lobbying audits is not really a surprise. It's just more of the same. And what we would suggest, and what we have suggested, is that the commission ought to focus more on getting this problem solved, because it is universal and not unique to lobbying. And there may be solutions to that. We've offered them in the past. In fact, your placement agent proposal would be one such solution, right, where you're eliminating from the lobbying pool a number of people who aren't really, quote, lobbyists, close quote, under the common definition or the common belief of what lobbyists are. That would result in a reduction in the total number of registered lobbyists significantly, which would then mean that the 25% draw would be a much smaller number, which might result in Franchise Tax Board being able to get to those lobbying audits. But in addition, there are other audits that are mandatory under the Act, and over time, the sheer number of those has gone up significantly, and I think I think Franchise Tax Board would tell you that it's just become overwhelming for them, and that if you want to help FTB get back on top of this, the way to do that is to take a look at who's being drawn for audit, and should there be some criteria for that. So I can give you an example of a couple years ago. There was a candidate for governor who ran for governor for all of 2 weeks, filed a committee, made a personal contribution of, I think it was $25,000, decided not to run for governor, closed his committee, and that's a mandatory audit, and that audit did take place. It was a number of years ago. But an example of 2 or 3 days of someone's time at Franchise Tax Board to chase down that audit that could have been avoided. So we would continue to urge the commission to look at other ways to help the Franchise Tax Board get back in control of their audit program without singling out lobbyists for unique treatment. That's all I have.
All right, thank you, Mr. Hilltack. Agree that placement agents certainly are part of this. That is part of the reason animating our proposal here. And I agree wholeheartedly that this isn't unique to lobbying audits, that in fact campaign audits not being done is equally concerning. I think Senator Glazer, if I recall, at the oversight hearing suggested that perhaps the FPPC should take both campaign and lobbying audit. So I think that's another approach that we could address Mr. Hilltack's concern, is by expanding the types of audits that we take authority for. So thank you, Mr. Hilltack. Commissioner Baker.
I think the point is well taken. For me, it's not an impediment to, I don't feel like it's singling out lobbyists. If we just did lobbyists, it is, we're going to take part of this problem. It's not the final close problem solve, I want to say final solution. It is it's the beginning. They'll have that much more time to work on candidate audits, especially if the placement agent and we are taking care of the lobbying part. I'm also very appreciative of the oversight that Senator Glazer did, that I'm sure IGS was commenting on, and I hope there's going to continue to be attention on this. One thing that has to be agreed on is the status quo is not working. It's not acceptable that since 2017, 18, several years ago, there have not effectively been 4 audits of all of them. And so I wouldn't delay what we're doing. I wouldn't not try to seek at least lobbying. I'm not sure I want to put in the legislation, then let's do all of them. I'm not there, and I don't think that's what you were proposing. Maybe that'll be part of the conversation. But I would at least move forward with this proposal and change the status quo that's happening.
Yeah, I mean, I'm open to taking it all, and I think Senator Glazer mentioned that for a reason, and I think he mentioned it because the reality is these are legally required audits that aren't being done. And every audit that doesn't get done is a violation of the act. And we have hundreds of them now, hundreds of violations of the act that nobody's done anything about. And so I think that's what's animating our legislative proposal here. So I'm hopeful that the legislature finds a way, one way or the other, to address this in the near term. Any other public comment on item 4? Hearing and seeing none, Ms. Contreras.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, that brings us to the end of our agenda for today. Item 5, discussion of items for our first 2024 committee meeting. Commissioner Baker, any thoughts, ideas?
I do, but this may be really actually more for the full commission, so I'll just throw it out there. Because we had a briefing on candidate-controlled committees that I believe was just at Law and Policy. We just saw that in our minutes.
Yes.
I actually wonder if that is something we would share at some point with our full commission colleagues, or if there wasn't, because I think we had this conversation. I apologize that I don't remember what we decided. But I'm going to raise that question now because we've already talked about it at the committee level. Is this an appropriate time for me to ask that?
No, it is.
Okay, good.
It's a great opportunity to bring it up and a great opportunity for me to mention that following that discussion, we asked staff to go back and analyze and provide a report
Okay.
on the number of candidate-controlled ballot measure committees that don't, essentially tracking their activity, how many result in an actual
Get some
ballot
data.
measure, how many are still open, et cetera, to gather the data to understand the scope or the magnitude of the problem, if there is one.
Thank you. You are barely younger than I am, so I'm glad that your memory is fresher where that landed. I wasn't sure because I didn't see it in the minutes, so I appreciate that. Two other ones that may be helpful, and there was I'm wondering if there's a memo on the authority of the commission to pass regulations. And I wonder if that's something that would be part of a full commission public meeting at any time, or that topic. Is that going to be part of the January conversation about the particular regulation? So it came out of the public comment from whatever month it was, August.
Well, are you asking for, because we have talked about the commission's regulatory authority
Yeah.
with specific reference to specific cases previously, and I know all commissioners have the opportunity to talk to
Yeah.
Mr. Bainbridge about the law outside a public meeting. So what,
I think I'm wondering if it's the January briefing that we're going to have, because I think that was highlighted in the regulation, will include regulatory authority, or is that just a separate, would you intend that to be a separate topic we would one-on-one talk with Mr. Bainbridge about? Perhaps I'm not landing the question well enough, but
yeah, I mean, for my piece, I think at any time, if commissioners have questions about the extent of our regulatory authority, they should feel comfortable calling Mr. Bainbridge and having those conversations, mindful that you can't then call me and then call another commissioner and start
Correct.
doing that, right? But if you have questions, call Mr. Bainbridge.
Got it.
If in a public meeting we have questions about our regulatory authority, for
Gotcha.
Mr. Bainbridge, I'm always asking him, are you sure we have the authority to do this? And we answer it. So if we want something more, I'm not sure it's necessary, but
Yes.
if you do. we
I
can
do not feel like it's necessary. I know we have a new commissioner, and I know that in January, we are having a briefing on some regulatory history behind one of the regulations, and I recall that there were questions about what was our authority. And maybe it'll all be there, and when January comes, if I have further questions, I will ask them then.
Yeah.
Okay. I think that is it for topics. I had wondered if there is a reporting on Form 700 of electronic, is it EFTs? Am I remembering the summary? Is that something that we are going to be tackling in the coming year, or is that something we want to have presented to Law and Policy?
I'd be open to that being presented to law and policy, just as kind of at a minimum, an informational, how are they treated currently? Is there additional regulatory work that we need to
Needs to be
do
done.
to make it clear for the regulated community. Because I've received questions from folks on
Yeah.
like, how do I deal with this? I understand that we do have advice on it already, but it may be an area where we can have a conversation.
Sort of informational. That would be the only, and I don't believe that is particularly time sensitive. I know in the first quarter of next year, people should be thinking about when their Form 700s are due, whether it's March 1st or April 1st. So maybe in the first quarter of next year, it might be at a law and policy meeting to just, and I could even just have what the advice letters are. It doesn't have to be an extensive presentation, but I know it's a question that has been raised a couple times. So thank you.
So, Mr. Bainbridge, I just want to make sure you understand the request for an informational briefing. Tell me if I'm getting this right. To the commission, an informational briefing at some point early next year on the reporting of EFTs on SEIs, what the requirements are, et cetera. Is that,
Yep, thanks for the
Fairly simple.
clear translation.
all right? All right, very good. Anything else, Commissioner Baker?
No, thank you.
All right, I will move that we adjourn. Do I have a second?
Second?
Ms. Contreras?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
Motion passes.
All right, thank you. Thank you, everyone. We will see you all next week.